Hey, it's James, Father's Rights and Resources, hashtag how I got custody. So, testimony is evidence. A lot of people will say, oh, she came to court and got a restraining order against me, but she didn't have any evidence. It was her word versus yours. Do you not know? A lot of people, now I may have done a video on this before, I've mentioned it in videos, but I wanted to make it clear because it keeps coming up. She won in court, but she had no evidence. Her testimony is evidence. Think about it. There's people who are in prison right now because a witness saw them stab somebody or run out of a bank or whatever. Witness testimony is evidence. Now, there's a bunch of um, studies about how unreliable witness testimony is. Like they've done studies where they show people an event and they have them walk through something, or they show them a video of something, and then they come back later and ask them, hey, what was the detail? What was the guy wearing? What was he doing? Or where did he go? And they don't even know. But testimony is evidence. And if there's a contest between two people and nobody has any emails, photos, voicemails, or whatever, then it basically comes down to your word versus hers. And then in civil court, you don't have to prove me out of reasonable doubt. You have to prove by preponderance of evidence. I probably should do preponderance of evidence video by itself. But you don't have to prove beyond a reasonable doubt that somebody did something or whatever. You just prove that, or you just tell your story, and then one person sounds believable. And they can do that in civil court. They can do it in criminal court too. But you got to prove beyond a reasonable doubt. In civil court, they just have to believe more likely than not that you harassed her or committed domestic violence. So, testimony is evidence. So, if I'm in a case, like I have been in several restraining order hearings, my baby's mom tried a restraining order, a couple of restraining order hearings at the beginning. Then I never talked to her after that, and she still tried restraining orders because I served paperwork at her home when her attorney wouldn't accept paperwork. So, she tried to get a restraining order on that. And she called my home to talk to my daughter, and I picked up and we started talking. And they, she tried to get a restraining order after that, and she's the one who initiated the call. So I fought off bogus restraining orders. I've fought off some with another lady after I got a restraining order against her. So if I'm in a courtroom and somebody testifies, and the only evidence they have, or one piece of evidence they have, is their testimony, I pick apart and destroy their evidence. So I attack their testimony. Your Honor, she just let me have the kid last weekend, and all of a sudden I'm a monster, and she decided to have a kid with me. There's some people I have, or there's all kinds of examples of, a guy I dealt with who used to be in a gang. A woman went to court and got a restraining order against him solely because he had been in a gang, and he had been in a gang 8 years prior, and they had a kid after they were dating or married, I think. And he left the gang, and they had one or two kids after that. That's evidence to destroy her evidence. That's me giving an analysis of her testimony to make it look non-credible. So it's bogus evidence. If somebody comes with fingerprints and you have a fingerprint expert who comes and says this fingerprint doesn't match the other one, and it looks like they applied the ink later on, and it couldn't have been impressed by, it couldn't have been it couldn't have been impressed by an actual fingerprint from somebody. It looks like it was mocked up or something like that. Then they attack that evidence. So if somebody has testimony as evidence, then you would attack that and find contradictions and loopholes and say, you can't possibly believe what she's saying because she's all over the map. He's a wonderful guy. I want to have a kid with him. Despite his history or his felony or his gangbang, and he's a sweet guy and he got his act together. Then all of a sudden, I'm a monster because I used to gangbang, or I have a felony in my history, or I have a violent crime in my history. And I went and got anger management, or I went and got some therapy, and now I'm a different person. Her story doesn't jibe with her actions. If I was a monster, she wouldn't have got together with me. She's obviously only using that against me right now out of desperation to prejudice me to the court, and throwing out some triggering buzzwords like violent, gangbang, and all these things to prejudice me to the court and get you in an emotional state. Now, a lot of times when I'm dealing with people with domestic violence issues, I got my packet in my store, Defense Against Protection Order packet, where I cite a whole bunch of attorneys, bar associations, and other people who make it well documented. It's well documented that women lie about domestic violence, child abuse, just abuse, period, in order to get leverage in custody battles. So, if there's lawyers and retired judges and entire bar associations writing about it, then I want to tell the judge, look at your own peers say that people lie about this all the time. If you just go in there and it's just your word versus hers, that you got a 50-50 shot at it, and it's actually even worse because we got radical feminist court systems right there. But I'll empathize with the court and say, look, Your Honor, you have a laudable or honorable desire to protect women and children. That's what the domestic violence laws are for. This woman is taking advantage of them and taking advantage of your empathy, and she's doing what many women do. There's countless lawyers, judges, and attorneys, like it says in my paperwork that I've quoted, that say women, it's more likely than not that women lie about this stuff. So she's coming to court and saying, I'm a monster, yet she had a kid with me. Yet she let me have the kid just a couple weeks ago. All of a sudden, I'm a monster in the past 2 weeks? You can't believe anything she says. And some of these bar associations say, more often than not, women lie about protection orders. So in a courtroom where the preponderance of evidence is the burden of proof is preponderance of evidence, which is more likely than not, and you got documentation from entire bar associations that more likely than not women lie, then in this case, it's more likely than not that she's lying. And then there's all these inconsistencies. See how you pile it on? Or, that's what I would do. I would pile it on. But people go in there and say, oh, she's lying. And then some of you guys are so delusional, you have no self-awareness, and you can't step outside yourself and think, wait, I'm talking to a total stranger. I know my life. I know she's lying, but this total stranger judge doesn't. I have to convince a total stranger. So if I just walked up on this couple and they're arguing over who's violent and who's not, I would want to hear overwhelming evidence that that person is lying, because I'm going to bend over backwards for the woman because they're the weaker sex and we want to bend over backwards and protect them. So I bring out this entire arsenal, especially the judge's own peers, and quotes from them. And I have, like I said, I have that in my Defense Against Restraining Order packet, or you can do your research for that. And then guys, they crap on their own evidence. Guys are like, oh, she did this to me. She's the one who assaulted me. She threw a brick at me. She threw a pots and pans at me. But I don't know. I don't have anything to prove it. Are you that stupid? Why do you think this, if you've ever watched a TV show with a legal scene or a movie or Law and Order, you can't be that stupid to think your testimony is not evidence. But for somehow people love to say this, but I don't have any proof. When you go to court and you tell them your story, your own testimony, eyewitness testimony, is proof. So you're saying that she was violent toward you several times in the relationship. She threw something at you, but you don't have any proof. Tell me this. When she threw something at you, were you there when she threw it at you? Stupid question, huh? Of course you were there. Just as stupid as thinking, I don't have any proof. If you were there, you were a witness to everybody just shits on that. We have such insecurity. We're such punk little bitches. Oh, I have testimony to say, something to say to the court, but I need proof outside of myself because that's not good enough. I'm not good enough. Like, come on, man. Now, you want to overwhelmingly prove stuff to the court, but if all you have is your testimony, then go for it and make some logical, passionate arguments and think about it. Don't wait until the last minute to prep. Don't wait till the last minute to call James or till after the hearing, after you get screwed. Get some one-on-one help. Get as ready as possible, because a restraining order hearing or any custody hearing is the most important hearing, is the most important day of your life, because your relationship with your child hangs in the balance. Once somebody gets a restraining order, it can steamroll from there or snowball from there. Once somebody gets a temporary order in place, that can set the momentum for the rest of the case also. So, witness testimony is evidence. Don't crap on it and don't make light of it. Be ready to attack it and be ready to use it on your behalf.